Hello, everyone. If we haven't met before, I'm Alex Norman. I'm the co-founder of TechTO. I'm an operator with 2 exits. I've dabbled in professional services, and I'm an active investor as a head of Canada for AngelList and a partner in 49P. Today, we have a very crucial live stream, a show that I think most founders need to learn more about. We're going to talk about IP exit strategy. I'm excited to welcome up our guests, Curtis, Brandon, Natasha, and Scott. Can you please join the stage with me?
Good morning.
Good morning.
Everybody.
We're slowly making our way up. Okay, we're all here. So maybe, I'll go around the circle and introduce yourself each with 30 seconds or less. Maybe I'll start with Scott because I see him up in my upper left-hand corner.
Thanks, Alex. Nice to meet everybody. My name is Scott Punsack. I'm a counsel at the firm, which, sorry about my phone there, that'll stop in a second. The landline, you can't turn those things off. Anyway, I'm counsel at the firm, which means I was a partner, retired from the partnership. I work part-time with the firm and part-time as sort of a fractional in-house patent lawyer for a couple of biotech startups.
Great. Brandon, you want to introduce yourself?
Sure. I'm Brandon Evenson. I'm a partner here in Toronto with the law firm Borden Ladner Gervais. I focus in all areas of IP with a specialty in technology. So I'm involved with a lot of trademark and patent type matters, including commercialization and disputes, and try to focus on a lot of the building value in IP portfolios for companies to succeed in the market.
Awesome. And Natasha?
Hi, good afternoon, everyone. I'm Natasha Galati. I'm an associate in the Ottawa office of BLG, and I work with these very esteemed colleagues, primarily in the patent space, but also some copyright and trademark work as well, helping people get IP and also protect their IP through litigation.
Excellent. I hope it's a bit warmer in Ottawa than Toronto today. And Curtis, last but not least, I'd love an introduction from you.
Thanks. Yeah, so Curtis Beeman, glad to be here. So I'm also a partner in the IP group, also based in Ottawa. I'm an electrical engineer, so I do a lot of patent work on both the hardware and the software side of things, some medical device work as well, and industrial design work. I'm also the national lead of Beyond IP Strategy, which is BLG's programs and services aiming to give kind of value-driven, proactive IP strategy advice to Canadian companies.
Thanks, Curtis. Can you give the audience an overview of what we want to get into today?
Yeah, so I mean, just to set the stage a little bit, I've been in IP for almost 25 years, and like IP assets can be complicated, and as many people will know, up to 90% of a company's value now is based on intangible assets, which include intellectual property. And so really having a wise investment in an IP strategy is really essential for business success. And I'll just give a couple of really quick stories just to give some context or some examples. So one company that we know about had a key employee walk out the front door with company trade secrets on a USB drive. And thankfully, it could have brought down the company. Thankfully, it didn't. But they spent over $100,000 in investigations and forensics, and all of that could have been avoided if they had, a proper trade secret protection program in place. A company that we worked with at West, they were a growing software company getting a lot of attention, and thought, hey, we should probably do something about creating some IP assets. And so our firm helped them prepare a couple of US provisional patent applications. It was maybe like a $20,000 investment. They did exit, and those patent applications, there was an additional $100,000 in value attributed to the presence of those patent assets. So that it's not often that you have a direct relationship, but in that case, they were able to identify that. And then on the other end of the spectrum, working with a large kind of energy company. They had a big patent portfolio and they were looking to assert. It was not inexpensive. They spent about $2 million in enforcement, but they ended up with a $700 million judgment. And so
Wow.
regardless of your philosophical thoughts about patents and the value of IP, it's hard to argue with a return on investment like that. And so really, what we're hoping to do is give some different perspectives to address things maybe in a bit of a different way than what you may have seen or heard. I know that along the way, Scott's going to give some context that looks at exits primarily from kind of an acquisition perspective, and then later on, Brandon will add some thoughts from an IPO perspective, which can be a little bit different. And Natasha didn't mention, but she also has an MBA, so she can bring that perspective. Brandon used to work at Deloitte, so he has that kind of consulting hat as well. So to be honest, if I were not participating in this panel, I would still be interested in hearing what my colleagues have to say. So I'm excited about it.
So I love that. It's not just engineering or business and legal. It's a combination of all perspectives. So it's
Exactly.
a multifaceted approach. I'm going to diverge from actually the questions right away. But before we get to that, the audience, if you have a question, there is that question tab. Put it up there, and we will weave them into the conversation. I already see a few questions up there. We'll get to them shortly. First, IP can mean many things to many people. So just would like to start with a basic. When you talk about IP, what are the different sort of what is the definition of intellectual property, and what are the different IP someone could have in a business? And it was completely not on our script, so anyone who wants to start with a definition, I'd love to hear it.
I'm happy to take a stab at this. I think you should keep in mind the two different categories of IP. There's things that you know as a company and that you do as a company that builds value that is not legally protected necessarily, but is simply that intrinsic value that you build. Then there's things that are actually protected legally as a head of IP. And there's only certain enumerated heads of IP. There's patents, which protects how things work, the utility. There's trademarks, which protects branding, right? Protects identity. There's copyright, which protects a work, such as a code. Somebody writes some code that's protected by copyright. And there's also trade secret / confidential information, which protects things that you try to keep secret from other people, and that is given legal protection. So those are the main heads of IP, and there's not much else. There's also industrial designs, I should say, but those are, depending on the country, in the US, they're called design patents, and each country kind of treats them somewhat differently. But those are the main heads of legal IP that are out there. And it's important to keep that in mind. And there's lots of things people want to protect as IP, but they legally can't.
That's interesting. Maybe we'll circle back to that then. Maybe talking about stuff that you can't protect as IP. But Natasha, Curtis, or Scott want to add anything to that answer, or is that a good definition?
That's a pretty good definition. I mean, beyond those main things that Brandon talked about, you get into things on the side that come up every once in a while. There are plant breeders' rights, which nobody cared about until cannabis became a thing a few years ago. Suddenly, cannabis varieties are important to protect under plant breeders' rights. There is an Integrated Circuit Topography Act, which protects the design of PCB boards. And there are, in other countries, there are various other forms of protection. China and Germany, for example, have what do they call them? It's called a Gebrauchsmuster in Germany, but anyway, it's a different form of patent protection that has a different set of rules. Yeah. Utility model in China, but companies in China use these things for and against each other, but we don't come across them here very often.
I'm going to assume most people right now are focused on Canada, but so let's actually, I'm going to steal a question from the audience because it's pretty close to the next question I was going to ask anyways. So Bruce Young asked, is there any generally accepted approach to valuing IP? And I'll give it to Scott.
Sure. There are. I mean, there are approaches to valuing IP in particular, and there are approaches to valuing IP that's embedded within a company. This is more of an accounting question than a legal question, but we get involved with it when a company is being acquired. The accountants and lawyers get together and they try and figure out a value for the company, either for the purchaser or for the company that's being sold. There's basically three approaches, and evaluator will use all three and meld the results from each of the three because they give different answers. The first approach is an asset approach, which essentially means making a list of everything, giving a value to each thing on the list, and adding it up. And typically that's a low value, and it's used as like a floor in it. When you're looking at IP in particular, it very rarely makes a dent. I mean, you can find studies that show that the average value of a U.S. patent is $50,000 or $75,000. It's not much. Occasionally, you get a single patent that is way out of the norm, that is worth something far more than that, and it makes a dent on the asset approach. There's a market approach, which is basically just comparing things in the market. So one company is compared to another based on some benchmarks, 8 times revenue, that sort of thing. And the quality, subjectively speaking, of a patent portfolio or an IP portfolio can move a company from 8 times revenue to 10 times revenue, or 8 times revenue to 6 times revenue if it's not well managed. And then the most important one is an income approach. And so for both patents and companies, an income approach is based on what is the future revenue that can be derived from this. So it's not looking at what's anything worth today, but what's the market look at 10, 20 years in the future. With IP, you want to basically create a monopoly. You want to say there's a niche. My niche is protected by this IP. No competitors will come into this niche. And then it's a blend of, well, what's that niche worth? And how sure are you that you can keep competitors out of that niche? So that's the primary thing we're looking at for valuing IP is what's your revenue stream 10 years into the future that is defined by a monopoly that the IP is creating. So the focus is really long term. It's not about what it's worth today. It's what's the market worth 10 years out.
Interesting. So I like that there's 3 different approaches, and hypothetically each one becomes more argument or theoretical based, right? If the future one, I guess you have to have a lot of, it's, I guess, logic based and lots of to substantiate your arguments. So,
Right.
I guess it goes to the next question, which I had is, are all types of IP as valuable as each other, and why or why not?
Well, they're definitely not. I mean, they're. I mean, you just hear in people talking. A lot of people will say that IP is useless, that patents have no value, and that is for the most part true. A lot of IP is useless, and a lot of patents have no value. But then, as in Curtis's example, you have a patent that was used to generate $700 million in revenue. So that one certainly is valuable. The value of IP is basically kind of geometric. I mean, if you look at patents, for example, 1 out of 100 of them is maybe really valuable, like worth more than $10 million, up to hundreds of millions of dollars. Yeah. But that's just 1 in 100. Maybe another 5 out of 100 are worth something material, like in the range of $1 million to $10 million, and the rest have a value that drops fast. And you do get to the point where some of them have no value at all. And I guess the second part of the question is you got to think about value to who. Some IP has a sort of a transcendental value, like it's worth just as much to one company as it is to another company. And some IP is really only valuable in the context of a specific company. So it's valuable to me or my company because it integrates with other things I'm doing, but I can't really sell it, even though it has value, because it doesn't really have value to the next company over.
So that's interesting. There's a question from our audience from Amanda Howard. It says, should I consider proactive IP protection? So my question here is, she wants to know when should she do proactive IP protection? And if so, how do you determine which, like, if there's such a variability in value of IP, where do you invest in doing that proactive IP protection?
Well, that is a fantastic management question, and that's kind of why it takes a long time to build an IP portfolio. It's not a one-time event. Whenever you have something that has a very geometric kind of value, you have to manage it accordingly and recognize that you don't necessarily know on day one what is valuable and what is not. So you make a few bets. You maybe make an excess number of bets, and then you watch that over the next few years. And when you see some element of IP, a particular patent, a trademark that is showing signs that it's more valuable than everything else, you dump your time and resources into that one and you roll with it. And then conversely, when you realize that some form of IP is not turning out to be valuable, you cut your losses and let it go.
Go on, Brandon. Do you have something to add here?
Yeah, and I think you should be turning your mind to IP at the outset, and for some companies in the industry that they're in, it's more important to have an IP strategy in place. Like if your business is entirely based on licensing your ideas to others, think of like ARM, like the chip designer, right? Their whole business is IP. So it is critical to think upfront about that. If your business is food, right? Maybe you make some sort of food product. Okay, not so critical there. It's really important to have an understanding of your business and figure out how IP fits in. And you can't make up for lost time when it comes to IP. Usually the issues that we see is because the business hasn't thought about IP at the outset, and they're 5 years behind where they need to be in terms of for the IP for the industry. So I think it's a good idea to look to the industry, look to your competitors, understand what they're doing, because that's what you're going to be benchmarked against. And certainly in an IPO process, you will be benchmarked against those incumbents that have IP at their core.
So I love this because, Curtis, you want to add something?
So I was just going to add one thing, just in terms of, if you think about, I mean, most people have some sort of, financial investments, and they have some sort of a plan, whether it's a big grand plan or something else. And really, like, intellectual property for a business is like a portfolio. You want to be kind of diversified. You want to start early. And if you think about it from that perspective, like Scott was saying, if something is doing well, like if in your investment portfolio something is doing well, you're probably going to invest more in it. If something is not doing well, you're going to pull your money out. And so you can have a similar thought process with respect to IP. It's not just a static thing where you make a decision and then you hope that it was the right decision. You're hopefully constantly tweaking it so that you're following whatever is most relevant and most valuable to your business at that current stage.
Interesting. This reminds me, like, one of the hidden talents of management teams is capital allocation. And it sounds, when it comes to IP and protection, it's another management leadership. Where do we allocate capital, and where's the right investment, which is what differentiates good and great leaders. So, and this is it's another asset, I guess.
It is. Go ahead, Brandon.
I was just going to say, and I don't think it's, we're not saying, everybody needs to have large IP portfolios. In fact, I think there's lots of companies that don't need any kind of IP portfolio, but you still need to turn your mind to it. You got to think about it and say, this makes sense for my business, and I'm going to put my money into a couple of main trademarks, and that's it. And I don't need to worry about patents, and copyright will take care of itself. So, sorry, Scott, go ahead.
That's okay. I just wanted to pick up on your point about, capital management, Alex, that, if you talk about what's the cost of securing a form of IP, say a trademark or a patent, the cost is actually quite variable. I mean, if you look at a trademark, you can file a trademark application for $400 online, or you can spend $100,000, $200,000 on it. With a patent application, you can find a way to do it for $5,000, and sometimes that's the appropriate amount to spend. In other cases, though, you might get involved in an opposition. You might get involved in some kind of invalidation procedure with a competitor. You need to decide then whether it's worth spending more into the hundreds of thousands of dollars on that particular asset.
Interesting. So I see a lot of questions around, like, how do you do this? What do you protect? I'm going to come back to those. I want to ask a few more questions, and we can get back into more of maybe the details. So let's take it back to a high level. Scott, can you give us a case study on how a company's IP and patents factored into an acquisition, and what happened post-acquisition?
Yeah, thanks. We have trouble generating case studies. I wish this could be like an MBA course where you have lots of case studies, but IP is inherently confidential and nobody wants to talk about it. So, from our point of view as lawyers, we need permission from our clients to give a case study, and no one wants to talk about what they're doing today. But I did get permission to talk sort of a little bit in depth about a slightly older case study where the time has passed and there's nothing confidential to release here. But let me give an example. Xenon Environmental is a company in Ontario that was formed as a spin out from McMaster University back around 1990 originally. What they make is a form of membrane filtration. Over their course of time, which is about a 15-year run, they took that from something on a lab to something that is municipal. So if you're in the town of Collingwood, for example, all the water in that entire town comes through a membrane filtration system that Xenon installed. And they have plants like that all over the world. So they were acquired in 2006 by General Electric for $800 million or so. $800 million in 2006 money is well over $1 billion in today's money. So it was a good run, it was a good acquisition. In 2006, when they were acquired, they had hundreds of patents. I mean, if you hundreds of individual patents. If you look at their worldwide equivalents, it was well over 1,000. But when GE bought them, I was involved for Xenon dealing with the acquisition by GE. GE really only cared about 2 patent families. There was one patent family that derived from a start in 1995, and it dealt with sort of the general architecture of their filtration units. And there was another patent family that had derived out of 1999 that dealt with energy conservation and reducing the amount of energy that these plants take to run. That was all GE cared about. And so I spent days with their accountants and their lawyers going over those 2 patent families. And GE's accountants did run a future forecast, sort of looking at what is the size of the market for these municipal membrane filtration plants, how much risk do we ascribe to that market, and in particular, how confident are we that these 2 patent families, which ended up being the only ones that mattered, will protect that market. So it went well. After the acquisition, though, GE's in-house patent counsel then wanted to sit down with me for a day, and he said right off the bat, I need to kill half the patents in this portfolio. They're not useful to me. They're gone. And so we did. We spent the day and we cut half the patents out of the portfolio. Clearly, go ahead.
So why kill? Is there a cost of maintaining a patent every year?
There is. Every patent has a cost to maintain it. In particular, foreign patents have a fairly heavy cost. There's an annual fee that has to be paid. So GE saw no value in half the portfolio and wanted that gone. They did save a few other pieces that turned out to be valuable later, but they had to cost cut. Xenon, from their point of view, they don't know who they're being bought by, so they had to maintain their bets because GE, as the acquirer, was interested in the municipal market. If it had been a different acquirer, some of their other patents might have had more value, so they had to play a few bets at the same time.
Interesting. So yeah, it's a portfolio strategy which you don't know what the acquirer is going to value.
Yeah, there's some management, there's some capital decisions to make, and there's a little bit of hedging your bets going on. But a couple things I do want people to take away from this example is that the most important IP can come up at any time in a company's lifetime. In this case, Xenon was sort of started in 1990, and its key IP was developed in 1996 and 1999. It's definitely not all at the beginning. I mean, I find in practice most often it's sort of years 3 to 7 of a company's life where the really good IP gets developed, or more or less after the company reaches its first market beachhead and gets in there, that's when the good stuff comes. So, no rush. If it's not often that a 2-year-old company has valuable IP, but the goal is to have a valuable portfolio 7-10 years out. I guess go ahead, Alex.
You said, and is there a second takeaway?
Yeah, the second takeaway was going back to moving your capital and effort towards the good things. The 2 patent families that turned out to be valuable, Xenon had definitely identified them as valuable. So, I mean, sometimes you see a chart of a patent process where you file a provisional patent and then you file an international patent and then you go into the individual companies. Xenon's chart looked nothing like that. I mean, we had multiple provisional patents. We had several U.S. patents coming out of the same family. Some of those U.S. patents had been issued, and then we reissued them. So we went back to the office a year after the patent had already been issued and applied to change it so that it would better cover what competitors were doing. We had patents that were opposed in Europe and Australia. So some competitor had seen our patents get granted and took a run at them, and we had to defend them in procedures that exist there. And there had even been a little minor skirmish in the courts where Xenon had sued one competitor and luckily settled after about 6 months. That competitor sort of voluntarily decided to back out of the market. GE, once they took over, though, embarked on a massive litigation plan and sort of more or less started a worldwide war with their two competitors.
Okay.
So there's definitely that imbalance in value, and in order to get the advantage of that imbalance in value, Xenon had to dump way more time and energy into these two families than it did in the whole rest of its family.
So I love this case study because it shows actually how it is like capital allocation. You have to understand where to double down on, identify the potential, and then figure out ways to extend the value of that patent by going to multiple countries, by going to related patents, and fighting to defend the validity. So it's a pretty cool example. Related to that, and I guess the next question I have is, and I see Amanda asked something similar, is like, how do I know what exit strategy is right for me? And I'll flip that into a question that says, what's the difference in IP strategy for an IPO versus an acquisition? And Brendan, do you have some thoughts on this?
Yeah, absolutely. And an IPO is a very different process to go through because you're dealing with a group of players who are higher up in the process. They're not necessarily in tune with how do I use a piece of IP in my acquisition to enforce against competitors. So they're looking at kind of metadata. The IP is important for two aspects in an IPO process. One is the market valuation. So what does the market going to value your company as based on the IP that and process and assets that you have in place? And second is the underwriter due diligence. We shouldn't discount how much of an influence the underwriters have on the IPO process and how much scrutiny the underwriters will give to a company's IP if they think it's material and it gives a lot of risk to them. Underwriters have significant liability exposure in IPO processes, and so they will spend a lot of time thinking hard and looking and scrutinizing a company's IP to make sure that they don't have significant liability or that they cover off those risks for themselves. So what are the main issues that we see in an IPO from a company's IP or lack of IP? So one is not having an IP portfolio consistent with the companies in the industry. And the folks, the market and the underwriters are not looking at startups, they're looking at the incumbent main players and saying, you're going to be one of them, you're going to go public, so what do they do, and are you doing the same thing? The second thing is exposure to patent infringement from dominant companies in a litigious industry. In some industries, there's a 600-pound gorilla, and they use IP to protect their market position, and they're legally allowed to do that, right? And it's very common, for example, in the medical devices industry, it's very, very common for there to be somebody like that. And the best protection in those cases is looking to freedom to operate and try to make sure you actually, in fact, avoid infringing those people's patents, which can be very difficult effort and expensive endeavor. The third thing that I see as an issue is having potential IP liability and IP disputes that are lingering. Maybe there's ongoing IP litigation. Maybe there's outstanding licensing fee demands from some people's like patent trolls or also patent pools like MPEG LA. It's not good to have those on the record, and they do influence valuation, and they do give underwriters some concern when they see that. Not to say you have to deal with those, but that you have a plan to deal with those and know how it's going to affect your IPO. The fourth issue that I see a lot of is not having legal ownership and having legal agreement issues. So not documenting or having legal documentation when you really need it to cover off IP. A big thing is not having standard IP clauses in employment agreements. It's an easy thing. It's not hard. Just get them in there. Not having contractor agreements that cover off ownership, the company's ownership of the IP. Contractors by default own the IP unless you have a written agreement otherwise. So these are very easy things to cover, and if you don't, then it's very problematic to the company, and you don't want to be dealing with those at the IPO stage. There's some other stuff too that go into kind of hygienic IP issues, but those are the main ones. The root cause, though, is that I see is folks not turning their minds early enough to IP and asking the right questions. It doesn't have to be complicated, it doesn't have to be expensive, but ask somebody and think through the IP process, understand how it works with your business. Because there's nothing like dealing with this at an IPO stage and you can't make up for that lost time. You can't catch up at that point.
Yeah, and imagine going to employees just before an IPO saying, "Hey, can you just verify you're signing this property? This intellectual property." The OS is an expensive process, and maybe some employees or contractors are no longer at the company.
You can't, and frankly, I've advised many times not to do that. You have this risk. You just have a risk, and what'll happen is the underwriter will cover off that risk for themselves by having you execute an agency agreement, reps and warrants that put the liability on the company. Because otherwise you're going to go to this employee and they're going to hold you up for ransom because they know you're doing an IPO or likely doing an IPO. So sometimes some of these issues you just can't fix. You can't fix it with money. It's just a known risk that you have to accept at some point.
So actually, I'm going to flip to a question from the audience. Joanna was asking, what qualifies for something that can be protected versus not? And same like from IP or copyright protection. So how do you know what you should be protecting versus not? What can be protected? And anyone wants to answer that?
Yes, there's different types of. Oh, sorry,
Go ahead, Natasha.
There's different forms of IP, and each one sort of has different criteria. So patents is the one we're talking about most frequently, I think, during this panel. So we'll start there. There's a bunch of criteria sort of outlined in the Patent Act, and also the judges in the case law. So give some hints as to what's patentable and what's not. Typically, called the trifecta of patentability is where you start. Is that something has to be new, useful, and non-obvious. To be that sort of threshold for inventiveness. Also has to be the right type of subject matter, not the wrong type of subject matter to qualify for patent protection. And there's a bunch of other things too. If you're looking at trademarks, something needs to be distinctive, and there's some other requirements in the Trademark Act for that. For copyright, you're looking at something that's an original creation that took some skill and judgment to create. So depending on what type of IP you're looking at, there's different criteria, and depending on your industry, some of those forms of IP are going to be more useful to you than others.
So Natasha, I love this answer, and I think it sounds like we can go much more in depth. So I don't know if people saw, what we might do with some of these questions is go back and get a bit more information so we can share it via follow-up to this conversation with, long form answer. Because I think it sounds like this is a very nuanced answer depending on the type of IP, your industry, and a bunch of other variables, which I haven't named. So I think that's a great answer. And we'll come back to it maybe we'll get a follow-up with a bit more, almost like we'll figure out something to share with the audience. Does that make sense?
Sure thing.
Yeah, and I'm going to stick with you right now. I have another question for you. How should a business-minded person, because you have an MBA, approach or try to understand the relevance of IP strategy to their business value? I think we've touched on it, but is it just capital allocation? What other angles to this is there?
I'm going to give a really simple, sort of very old soundbite, I think, just to start off with, which is start with the end in mind. So most of the returns that you're going to realize on your business, you're going to realize at exit. And just remember, IP doesn't exist in a vacuum. It exists in the marketplace. So in the marketplace for your products and services, but also, in the case of an acquisition, in the marketplace for target firms. So think of it from an exit perspective, decide what kind of exit you're shooting for. And, as Scott said, it's a long game. So work backwards from there. You can make those IP decisions along the way to really serve your business with an end goal in mind. And you can also kind of approach it from a functional perspective. So what do you need the IP to do for you? Is it sort of a magnet to attract investors or potential buyers? Are you looking at it as sort of, way of to protect market share. When the time comes, you want to make sure that the right things are protected, the right aspects, the right layers of IP are in place, so you can have sort of the strengths of one kind of form of IP compensating for the weaknesses of another form of IP, and sort of layer it up and build a very comprehensive shield, so to speak. And there's of course all the hygiene issues that Brandon was talking about earlier, making sure there's a really clean chain of title and any security interests you're aware of, pending litigation that you might need to disclose. But I think ultimately, if you have an idea of where you're going, you can make informed decisions along the way about your IP, whether it be capital allocation or something else. And think of it from the market's perspective, because a buyer he's buying your business, they're not buying a headache, or they're not in the market for a headache, right? So you want to make sure that all those different pieces are in place. Timing is important. So you've got patent applications, for example, have these really malleable claims, so you can go ahead and amend them to make them fit your business approach along the way, and that might be really appealing to a buyer if it's an acquisition. Whereas if it's an issued patent, it's a little bit trickier, almost impossible to have the scope change of your patent, but you can sort of enforce it right away. So if the end game is to use as an enforcement tool, then maybe an issued patent is a better option, and you can sort of use the tools in the process to sort of make adjustments to your timing and use your IP strategy to kind of reinforce your other strategies. Your IP strategy will only make sense insofar as it supports your business strategy as a whole.
So I love that. Like, I think that last soundbite is, very important. Your IP strategy feeds into your overall business strategy and vice versa. And so for two companies that look very similar, if they have different strategies, they can have a whole different approach, is what I'm hearing. Interesting. Cool. Now I want to get a bit more into the industries we're dealing with. I imagine there's a lot of people here that are in the software business and, or a web business, which is basically software. Was there any special considerations for them, patent considerations? And maybe I'll let Curtis, because Curtis, you've been nice and quiet since the introduction. So I don't know if I should send this to you first or someone else, but like, what are special considerations for either, software businesses or medtech businesses?
Sure. So a couple of things. So there are some rules about what can be patented in terms of software. So if your patent claim says software for doing X, it won't fly. But if you use kind of the wording that patent agents all know is the right wording to use, then it's likely to get through. But some patent offices and patent examiners may raise some red flags if you describe things in certain ways. So that's why it's important to work with people who know not just how to draft patents, but how to draft patents that will withstand examination in the US according to their rules, in Canada, in Europe, in Japan, wherever you're going to get protection, because each patent is only going to protect you in that jurisdiction. And so you want to make sure that you're writing it in a way that makes sense. I mean, Natasha referred a little bit to kind of layering of different types of IP. And so often with software, you're going to keep some of what you're doing secret. And then the stuff that someone can easily either reverse engineer or figure out what you're doing, you'll more than likely try to patent those things, because otherwise people are just going to be able to kind of steal it. And so, you're usually looking at a balance of what am I going to disclose, because you have to disclose what you're going to protect, and what am I going to keep secret. And from my perspective, underlying all that, there's what your software actually does and why your customers choose your software. And, the things that you pitch to potential customers or investors, things that you keep repeating, those are the things that you should probably think about. Do we have any IP in place to protect those things? Because anyone else can try and compete, but if we're constantly saying these features are what sets us apart, those are the things that you should really try to focus your IP investments in.
Cool. Anyone else have anything else to add about those particular industries, Brandon or Natasha?
Yeah, I mean, I think it's a good indicator to look at the existing industry players to figure out what they're doing with their portfolios. What you'll find is, like, in the tech company world, the public companies tend to build their IP portfolios, not necessarily so that they can sue or enforce them, but it tends to be kind of one of their motherhood elements to their business. They build their IP portfolios. So Google has stuff covering their back-end web search technology. Facebook has stuff, right?
Yeah.
You got middle market folks in the SaaS space who don't tend to file a lot, and it's because all the code and know-how is hidden behind in their server farms. And it will never see the light of day. And there's no need to disclose it publicly by filing a patent application, which is a requirement of filing a patent, getting a patent. You have to disclose your secrets publicly and the secret ingredients. So I find a lot of folks say, listen, it's not worth the investment. There's no need to, and it's actually kind of harmful to disclose our secrets. So we're going to keep this as confidential information. It's all protected as copyright as well. The code is itself. So we won't go there. But if you're a medical devices company, your device goes out into the public, and it is a very litigious industry for patents, and there is a lot of focus on patent protection. So that industry, yes, there's a need to think hard about your patent portfolio, and that goes all the way from small startups to the large players and everybody in between. So I think there is a significant difference, despite both of them kind of heavily involved in software and software having eaten their worlds. It's important to just focus on the actual industry and what the industry is up to.
Very cool. Yeah.
So just to add on the med tech side, regardless of whether you're going for an IPO or an acquisition, or you're just going to sell it to your neighbor down the street, I think it's really important to make sure you know your audience and subject matter. So you want to make sure the right things are protected, because like engineer is going to engineer, right? They're going to improve things, they're going to innovate, they're going to change the tech. And the investors want to know, people who are interested in what you're doing want to know that the key differentiators are protected. They're covered. So if that person buys your IP and they pull apart your device, your medtech device, and they change certain things, is the nugget of what you've contributed, the inventive thing, is that still going to be covered when that company turns around and tries to sell it, right? And also, I mean, medtech is highly regulated. It's a highly regulated industry. Public companies are highly regulated as well. So if you're thinking of IPOs, just kind of be aware of the layers of red tape as things progress. But ultimately, it's the utility of the tech and the claims to the actual invention.
Yeah, I've dealt with FDA a few times. It's a lot of fun.
Hold on. Sorry, I just wanted to jump in and say one more thing about software. The number one problem that I see in acquisitions is with open source code. I mean, most software has some open source code in it, and the acquiring company will sort of request disclosure of every bit of open source code that's in there, and we'll look at the particular license terms that apply. And some of it's okay, some license terms are not, and it can sort of derail an acquisition if the code has to go back to the drawing board so we can extract the open source software from it.
Interesting. So be aware of open source.
And I can tell you in an IPO process, the underwriters will also dig into that. So it applies equally for IPO processes. Yeah.
Okay. So it seems like be aware of the terms and conditions of open source and if you follow them or not. You've answered all the questions I have. There's still a few from the audience. I'm going to take one from Joy. She asked, basically, we didn't talk about trade secrets. How can I go about? What are some practical strategies to protect my trade secrets?
Keep it quiet.
so yeah. Is it like with the put the like for the food companies, they put the secret formula in the vault and only
the big elaborate vault.
Yeah.
With food, that's kind of an interesting example, right? If there's wet ingredients and dry ingredients, keep them separate, and that's kind of a metaphor, right? You can kind of split up your secret so that no one person is privy to the whole thing. You've got all of these cybersecurity measures, encryption and all of that stuff to kind of keep it confidential. Make sure you got your non-disclosures in place. Brandon alluded to employment agreements earlier. Make sure all the right clauses are there. Same for your contractors. I don't know, Tim, what else is there's a bunch of different sort of strategies you can use.
Well, let me throw in there that the number one thing to do is to just talk to all the employees in the company and make sure that everybody understands what are the confidential things and what are the not confidential things, and that the confidential things are important. The legal protection of trade secrets is just plain weak. I've never lost on the defense side defending against a trade secrets claim. It's nearly impossible to prove that someone stole your trade secret. So you got to stop it from happening. And the best way to, first thing is to make sure everyone in the company understands what the confidential stuff is, and put some procedures there to make the message clear. Mark the things as confidential. Say that we have a special filing cabinet or a special server where this stuff goes. Put a bit of procedure around it just to subtly remind people that this is the important stuff and this is the stuff that's okay to talk about.
So it shouldn't be on a url.com/trade secrets available to the world.
I can give you another crazy case study here. I defended a software company in Toronto once from NASA. Like NASA was suing them. NASA was the contractor. Pratt & Whitney was suing my client.
Yeah.
And it was a trade secret case. And it turned out that some of the engineers were posting bits of their code for discussion on an online discussion board. And so we found it all.
Yeah.
It was game over. Like, well, Your Honor, this is the secret stuff. We just dragged it off.
Publicly available.
Yeah.
Yeah. There's a bunch more questions about international. I'm going to actually skip on them right now because I think that might be, just conscious of time. I want to get sure that you guys have a chance to network with the audience. And maybe I'll talk to the team behind the schedule. Maybe we can get some questions about international, because I imagine international, every country, every situation is different. And I don't want to get to too much generic advice that's not going to be applicable. So what I'm going to do right now is I'm going to thank Curtis, Brandon, Natasha, and Scott for joining us today. I'm going to tell you, if you like this and you like what TechTO has, subscribe to a newsletter so you'll be informed of future events and you can get, potentially some of the information we're going to share after this. And stick around if you have time. We're going to open networking up till 1:30. You get time to meet people. If any of the panelists have time to stick around, you might be able to chance to chat with them and ask your international IP questions or any other questions, or you get meet people from the community. And what I ask for you when you network is get to know the community, get to help each other. We're all here to build this great tech ecosystem across Canada. And I appreciate everyone for taking time on a Tuesday to join us at lunch, and at least East Coast or breakfast in the West Coast. Thank you so much. And if you enjoyed, you can see me again on Thursday at Quick Takes, where we analyze some of this week's tech news. We'll open up networking now.
Thanks, everyone.
Thanks very much. Thanks for having me.